5 seconds to go. Start. In any other case where the court arrives at the conclusion that recovery, if made from the employee, would be iniquitous or harsh or arbitrary to such an extent as would far outweigh the equitable balance of the employer's right to recover. Recently, this court in Thomas Daniel versus State of Kerala and others held that the state cannot recover excess amount paid to the ex-employee after the delay of 10 years. The government resolution dated 8 February 1999, to be specific, the highlighted portion supra is amenable to the interpretation that it protects the status and pay of those employees who had received their time bound promotions prior to 31st December 1995. As a consequence, the Secretary concerned, while rejecting the representation, clearly misinterpreted and misapplied the said resolution to the detriment of the appellant. The learned single judge, as well as the division bench of the High Court of Patna, also seem to have fallen in the same error. In addition thereto, we are of the view that any step of reduction in the pay scale and recovery from a government employee would tantamount to a punitive action because the same has drastic civil as well as evil consequences. Thus, no such action could have been taken against the appellant, more particularly because he had been promoted as an ADSO while drawing the pay scale of rupees 6,500 to 10,500 applicable to the post way back on 10th March 1991 and had also superannuated 8 years ago before the recovery notice dated 15th April 2009 was issued. The impugned action directing reduction of pay scale and recovery of the excess amount is grossly arbitrary and illegal and also suffers from the vice of non-adherence to the principles of natural justice and hence the same cannot be sustained. The order dated 8th October 2009 passed by the state government directing reduction in the pay scale of the appellant from rupees 6,500 to 10,500 to rupees 5,500 to 9,000 with effect from 1st January 1996 and directing recovery of the excess amount from him is grossly illegal and arbitrary and is hereby quashed and set aside. The impugned order dated 27th August 2012, passed by the division bench of the High Court, does not stand to scrutiny and is hereby quashed. Therefore, the appellant shall continue to receive the pension in accordance with the pay scale of rupees 6,500 to 10,500. In case if any reduction in pension and consequential recovery was effected on account of the impugned orders, the appellant shall be entitled to the restoration reimbursement thereof with interest as applicable. The appeal is allowed in these terms: no order as to cause. Pending applications, if any, shall stand disposed of. Stop.